Good morning or good afternoon, everyone. Thank you for joining us today. This is our final webinar of 2024 in the estate litigation series. The topic today is your estate plan. Plan now or litigate later, and you'll hear precisely why. My name is Jonathan Lancaster. I'm a partner in the litigation department in Fasken in Toronto. I have a broad-based practice, commercial litigation, real estate litigation, and also estates litigation, among other areas. I'm going to introduce momentarily our two panel members. There is a slide, I think, to come up on the screen to provide information on how we're going to proceed today and troubleshooting. I'd like to draw your attention to the survey piece in here. We value your feedback and input, so by all means, please provide and fill in the survey and provide us with your comments. Today's session qualifies for a variety of credits depending upon the jurisdiction in which you're in. And at the end of the session, there'll be a QR code and links available for you to complete an automatic certificate. And if you don't have the forms filled in today, there's an opportunity to do them at a later point. First of all, I'd like to introduce Karen Wyke from our Calgary office. She's a partner in the litigation department. Also has a broad-based practice involving construction, complex commercial litigation, contract litigation, arbitrations, as well as, of course, estates litigation. Karen has been named as a litigation star in commercial litigation in Alberta and one of Canada's top 100 women in litigation, and Karen has been practicing for over 20 years. From Vancouver, Eric Clavier, who's a specialist in trust and estates litigation, has been there for 20 years. He assists clients in resolving contentious matters relating to wills, estates.
And Eric, I think the point has been made, has a very focused practice on all manner of litigation involved with estate and trust litigation. So I think we'll move on. The topics we are going to cover today, given that we are all litigators, even though we're talking about estate planning, is estate planning, which involves wills and trusts and planning for incapacity. And as litigators, we'll be talking about some of the things that we see as litigators for as a result of either failing to plan at all or planning poorly. So if you could move to the next slide, please. So I will first be talking about estate planning consequences of either failing to plan or planning poorly from a will's perspective. If you could move to the next slide. And before we get there, we thought it would be important to sort of set the table on what your estate includes. So in some instances, you may not actually have many assets or an estate, or when you're planning, you have to decide what you are drafting a will over. So if you have life insurance, the benefit of life insurance, I'm not a life insurance agent, but is that it gets distributed outside of a will, and it is not subject to your terminal tax return, nor does it have to be probated. So when you are drafting an estate plan, you want to, if you have significant life insurance, you want to be looking at the beneficiaries of that life insurance and how they will benefit, and that will inform your estate plan. It also excludes any assets owned jointly. So if you are married or and you own a home or you have joint bank accounts, there is something in law called the right of survivorship. And the person you own those assets with jointly, also those assets will immediately transfer to the survivor of the two of you. And it's not always limited to, of course, spouses, but that also is a big benefit. So when you are drafting a will or a trust or your estate planning in other ways, you want to think of your excluded assets from the estate plan also in determining who gets what. Another asset that is excluded generally is RSPs, where a designated beneficiary of the RSP is your spouse. They get to take advantage of some spousal rollover tax issues. So first we got to decide what the estate is. It's everything outside of those things. And there are three central aims, I would say, of an estate plan. One is to provide a distribution of your assets that do not include those assets I've just identified, to appoint an executor or a personal representative of your estate. They have a lot of duties: disposing of your body, distributing the estate in accordance with your wishes, managing any litigation that arises as a result of uncertainty in your will or other testamentary document. And so you want to choose that person or carefully, and we'll go into some considerations there. And the other, of course, is to identify a guardian for minor children. Next slide, please. As I mentioned, there's options for estate plans. There's your last will and testament, typically a written will. Other options include, which my colleague Eric will be speaking about more in depth, is trusts, joint ownership planning. In some cases, that people like to take advantage of the right of survivorship, and in very simple estates, they plan either wholly or partially to own property jointly to avoid wills and probates and that kind of thing. It's not always suitable. And then there's also dual wills for private company shares. Next slide. So if there is no estate plan, no will, for example, then there's consequences often. As I mentioned, you're the administrator, personal representative of your estate, may need to be appointed. They have a lot of duties, as I mentioned, including disposing of your body. There can be litigation if there is no administrator and there's a tense family situation. Even disposal of the body can be a big issue. The biggest thing, of course, is there's uncertainty surrounding beneficiaries. If you die without a will, that is, you die intestate, it's called, and every province has slightly different rules on how an intestate testator's estate is distributed, and there's legislation, and it's very ripe for family conflict. In Alberta, I'm from Alberta, the rules generally are, if you have no kids, everything goes to your spouse. If you have a spouse and kids with that spouse, everything still goes to your spouse. If you have a spouse and kids, but not with that spouse, 50% will go to your spouse, and the remaining 50% will be shared pro rata. But every province is slightly different, or some of them are the same, but it can be quite complicated. And then a big issue for those with young kids is that if you don't have a will and you haven't appointed a guardian, technically the province may become the guardian of your minor children, but often there can be disputes about who will become the guardian of your children. So it's not generally advised if you are thinking about how to benefit people, or you have minor children, not to have a will. Next slide. No such thing as a simple will. There is no such thing as a simple will. I mean, we did have a question before the seminar about will kits. In some cases, if you have a very simple estate, no children, those kind of things, Sure, it's not very expensive to seek advice in respect and to have a will drafted for you. And there's many reasons to do that. There are formal requirements for wills and codicils and holograph wills. A holograph will is a handwritten will, but it still has to comply with formal requirements of provincial legislation. It's very important. I mean, a will is a testator's last ability to speak for themselves, and the will has to be testamentary in nature, and there are some solemn requirements and formalities to a will. In Alberta, you have to be over 18. The will has to be signed by the testator. That signature, anything below it is not binding. It has to be witnessed by two people who are present at the time when the testator signs the will. So there are a lot of formal requirements. Those witnesses cannot be beneficiaries under the will. If they are, that benefit can be or is on its face invalid. So there's a lot of technical requirements. I would say across the provinces, they're likely much the same, but there may be some variations, and it's set out in legislation. In Alberta, particularly, and in most provinces, the intention of the testator is supreme, except that testators must make provision for their dependents, and I will explain who that includes. And if a testator does not, a will, their last will and testament can be varied. In BC, there is an ability to vary wills outside of that requirement. In most provinces, it's the only basis on which to vary a will. It's very important that testators make provision for the dependents. There is a policy reason for that, of course. The government does not want to pay for your failure to maintain those who are dependent upon you financially. There's also residency requirements for personal representatives or executors, and even within the province. Next slide. And again, we've included this slide just to show, along the punchline that there is no simple will. There are a number of tax issues that should be considered when you're drafting your will, and all the more reason not to rely on those will kits. There are capital gains taxes, attribution rules, tax on split income, property transfer taxes, speculation and vacancy taxes, and probate fees to consider. There's first-time home buyers benefits and lifetime capital gains exemptions. And so not only are you seeking a lawyer to ensure that you're meeting the formal requirements and that you're adequately providing for your dependents, but the whole other aim of an estate plan is to ensure that you are planning your estate and the transfer of your estate assets in as tax efficient manner as possible. Next slide. Okay, making adequate provision for dependents. Now, this may seem like it's pretty straightforward, but who qualifies as a dependent actually varies in some ways quite considerably from province to province. So obviously a spouse is a dependent, and that's a legal a marriage spouse. A common law spouse, or also known as an adult interdependent partner, is also a spouse and a dependent. But in fact, there is in Alberta, and I believe in other provinces too, entire legislation on what defines an adult interdependent partner. And I know from litigation that I've been involved with that requirement is actually different across the provinces, and slightly different, and in some ways significantly so. In Alberta, a common law spouse or adult and interdependent partner is somebody that you have been living with for a period of 3 years, supposed to be continuous, in a relationship of interdependence. And what we're seeing in Alberta is a ton of litigation on even whether you meet the requirements. There has been some developments in the case law that consider what living together means in the context of somebody who works away from home, or if you go on holiday together. There's been a lot of case law on interruptions and breakups during that period of time. And so, again, if you are in a common law spouse situation or think you might be, and in Alberta, again, it's a 3-year period, you can enter into sort of a prenuptial living together arrangement to make sure that somebody that you didn't intend to be your dependent and who could vary your will and your intention, you can enter into an agreement with them so that you have some control over the entitlement there. But we're seeing a lot of litigants who are trying to make themselves adult interdependent partners and then seek variance of the will when they haven't met those requirements. And so the law is really developing on that. What other family members qualify as dependents? Again, it may be slightly different in provinces. Minor children are considered dependents. Grown children in Alberta typically are not, unless they are unable to make a livelihood because of their physical or mental disability, or they are between the years of 18 and 22 and are a full-time student and are living under the charge of their parents. So again, these are people that you need to make provision for, and if you don't, if there's poor planning, they can seek to vary the will through very expensive litigation. And what provision is adequate? With a spouse, there's a lot of case law on this as well at the Supreme Court of Canada level and throughout the provinces. The courts really look in a spousal situation to entitlement upon divorce, and also for all dependents, they look for the lifestyle that was enjoyed of that person while the testator was alive. And just a point on stepchildren, generally they would not be considered a family member or a dependent, and so you do not need to make provision for them. There are exceptions. The next issue that we see in the next slide, from you've made a plan but perhaps not executed perfectly, or there's been poor planning, is where a testator makes a formal will, last will and testament, and makes a memorandum of wishes on the side. And a memorandum of wishes typically is appended to a last will and testament drafted by a lawyer, and it gives some instruction to your personal representative on how to exercise a discretion that you've say granted in the will. So say, for example, you want all of your personal items, my jewelry. I want my jewelry to be distributed generally among my 3 children equally, is what you've said in your will. You might give some direction on how that's to be distributed in a memorandum of wishes. Each child should have a ring, a bracelet, a necklace, whatever. It's maybe, this is how you should exercise a discretion. What we've seen, particularly, some people will draft a memorandum of wishes in a handwritten notation that is then signed. That's known as and dated. That's known as a holograph will or codicil. It can take on a life of its own. It can alter a will. It can change gifts that have been made in the formal document, and so it's not precatory in nature, it's called. It's more testamentary. It's capturing the final intention of the testator. And there can be cases of even a number of those memorandum of wishes that would qualify as a holograph codicil or an amendment to the will, and they can be binding, and they can result in very expensive, protracted litigation as well. They can be binding. Next slide. The other thing to think about is if you're thinking about disinheriting, you have to be careful who that is. Obviously, if you disinherit a dependent, particularly a spouse, that won't stick. Your will be subject to a dependent's application for maintenance and support. But what we see mostly is a case of a testator with grown children who wants to maybe disinherit one of them. Maybe they're estranged. I think if you were to consult an estate planner, which I'm not, but a litigator, they would advise to provide an addendum to the will explaining the reasoning for that. Again, these are just ways to litigation proof. It becomes quite relevant in BC because there is a broader ability to vary the last will and testament of a testator under the Wills Variation Act. And certainly, and Eric, feel free as a sole estate litigator in BC to talk about, what you see sort of from grown adults and how important it is for somebody who's being disinherited as a grown child to provide reasons.
Yeah, I think that's a great point, and it is very BC specific. So what I'm about to mention is limited to British Columbia, but in British Columbia, you don't have to show financial need or dependence in order to be in a position to vary the will. It's a much broader analysis, and provided you are the common law or legal spouse of the will maker, or one of their natural or adopted children, you have that ability as a matter of right to apply to court to vary the will if you feel that the will does not make adequate, just, and equitable provision for you. And while you can try and litigation proof that at the planning stage and putting a memorandum of explanation together or having some kind of reasoning, it doesn't mean that the litigation won't result, and it doesn't mean that the litigation won't end up with a variation of the will. So in BC, at least, making a will is one of the tools in the toolbox when it comes to planning your estate, but it is also one that is subject to potential challenge under our Wills, Estates and Succession Act.
Yeah, thanks, Eric. It's a very different experience. If you wouldn't mind moving to the next slide too. Other issues with poor planning, again, people try to avoid terminal taxes and probate, sometimes by the joint tenancy issue. That's ripe for litigation. Often there'll be an uncooperative child. There are creditor issues. Often tax consequences have not been taken into consideration. The other issue is where you've poorly planned, perhaps, is where you have appointed personal representatives who are not residents either provincially or out of the country, and there are lots of tax issues and complications with that. Particularly, personal representatives in Alberta have to post, who are out of province, have to post a bond, and it's very significant, and it is to ensure that beneficiaries who would have a claim against a personal representative who's not doing their job at least have money to a bond, something paid into court to ensure that there's something there for them if the personal representative is negligent or in other ways. So there's lots of traps, both with not having a will or poorly planning, and they can result in litigation. I'll just go through some of what we've spoken about. Next slide. With no will, there can be disputes between beneficiaries under intestacy legislation. There can be applications to appoint an executor to carry out the executor's duties, and there's lots of them. And there are applications to vary public guardianship of minor children. So there are lots of and we see them all the time. There's lots of different kinds of litigation that arise where a testator dies intestate. Poor planning also results in litigation. Next slide. We see if there are dueling wills or dueling memorandum of wishes. We see applications, even trials for proving the formal will. There's applications to validate handwritten instructions. There are applications to vary the will, by far the most prevalent, for failure to make adequate provision for dependents. And in some provinces, the applications to vary the will where obvious beneficiaries are disinherited. So I think that's it from a wills perspective. I'm going to turn it over now to my colleague Eric to speak about other estate planning options.
Thank you, Karen. And so before I start and get stuck into trusts, which is an alternative planning option, which is available in many cases and a very effective planning tool as well. Generally speaking, when people speak about an estate plan, they'll speak about three different types of documents. The first is a will, which Karen has discussed. The second is a power of attorney, an enduring power of attorney, which I will discuss a little bit later on. And then the third is a document that allows somebody to make substitute decisions on your behalf when it comes to your health and decision plans and decisions that need to be taken regarding your health and care considerations. Those are the three basic documents, but it's no one size fits all. When we say there's no simple will, there's also no simple estate plan. If your estate is somewhat complicated, you should really go and meet with an expert estate planner, because they'll be able to discuss with you the options that are available to you, including trusts. Now, what is a trust? Essentially, a trust is established in one of two ways. It's either testamentary or it's an inter vivos trust. And it's essentially a relationship where you appoint a trustee, someone who's going to hold your assets and deal with them in a manner of your choosing. And so the testamentary trust is the trust that you would create through a will, for example, where you make provision in your will that the assets that come into the possession of your executor trustee are going to be dealt with in a specific way. They're not going to be distributed out immediately to beneficiaries. But for example, if you have children that are under the age of 19, you may want to hold off distributions until they reach an age where they might be a little bit more mature, such as 25. You might want to have it pass out to them in portions over the course of several years in order to avoid them squandering the money, for example. But it doesn't have to be with respect to minor children. It can be with respect to anybody. You have that ability in your will to create a inheritance scheme or a structure that gives you the control as to what happens after you pass away and protects your beneficiaries, protects the assets that are being passed on to them. So that's one way that you can have a testamentary trust, which would be through your will. Another is a life insurance trust, where you would have a life insurance that pays out, but the funds are held in some form of a trust relationship. The trustee would be dealing with those proceeds in a specific way. And when you have minor children and you name them as life insurance beneficiaries, generally speaking, the insurance companies would require that you appoint a trustee in order to manage those funds until they reach the age of majority. The second type of trust is the inter vivos trust, which you would set up as the donor or the trust settler during the course of your lifetime. In other words, it doesn't only take effect upon your death, it takes effect immediately, and you can set out how the assets will be dealt with in the here and now and in the future. And you would transfer your assets into that trust during your lifetime, because the trusts that are testamentary in nature, the assets only pass into the trust upon your death. Whereas the inter vivos trust, you do that during your lifetime. And so when it comes to inter vivos trust, there are a myriad types of trusts that you can set up for different reasons, for different tax planning situations, for different family situations. And we're going to touch upon some of them today, but given the time constraints, I'm not going to be able to go into too many details, but I'll give you the high-level overview of the types of trusts that are helpful in an estate plan. Why a trust? What would be the possible benefit of a trust as opposed to an intestacy, which is not advised, or just having a will that doesn't set up a trust? The first main consideration, I would suppose, is that a trust is private. A will that gets probated is not private. It has to pass into the court. And so anybody who wants to stick their nose into your business would have the ability to go and look at what's in your will and who benefits under the terms of your will. A trust that is an inter vivos trust, i.e. not a testamentary trust created by that will, would be private. And it would only be the beneficiaries and the trustee or the trustees who would have the ability to know what is in it. And especially if you have significant wealth, that is a good benefit to have, because nobody would then know what is passing and what your net worth is and what your children, for example, stand to receive. The other major benefit is that you maintain control of your assets. So in other words, you have complete carte blanche as to how you're going to deal with your assets and who should receive them, at what time should they receive them, what benefit pays out. Are you going to have a situation where only the income generated by a trust gets paid out to beneficiaries and the capital doesn't get encroached upon, so that it is preserved over years in order to provide for your family or to provide for your beneficiaries for longer and keep those funds preserved? You're also able to protect assets in your trust. In other words, there's creditor protection because your assets are now held in trust and they're no longer in your personal name. And it's easier, quite frankly, to transfer assets out of a trust to beneficiaries than having to go through the probate process. In BC, at least, the wait for the probate registry to be able to process your application for probate is significant. It takes several months in order to get a grant of probate. And the grant of probate is necessary for an executor who's armed with a will to be able to deal with your assets, dealing with third parties like banks, dealing with public companies when you hold shares within them, dealing with the land title office, trying to transfer your property or sell your property. So that is harder to do if you have a will and you don't have a trust. There's the wait, and there's also the having to pay probate fees in some provinces, which can be fairly significant as well, depending on the value of your estate. And so when you have a private trust, which doesn't require probate, you are able to transfer through your trustee assets much more simply and efficiently than you would have if you didn't have a trust in place. Creditor protection has many different forms, and provided you are not trying to settle assets into your trust in order to escape a claim of which you are already aware, that would be a fraudulent conveyance. But if you set it up in such a way that down the road there's the benefit of creditor protection, that is not an impugnable settling of a trust. It's not a sham trust, and it protects not only the assets against creditors, but it also protects your estate plan from potential wills variation actions, such as claims by dependents. Because one of the things that you need to bear in mind is when you make a will, you are essentially saying, this is how I want to determine my estate once I pass, but it's always subject to the court's involvement. When you do a trust, the court doesn't get involved in that manner, and you're able to prevent your child, for example, who's a spendthrift or that you're estranged from, making a successful claim for wills variation because you put your assets into your trust, and that is not subject to the Wills, Estates and Succession Act. There are also possible tax savings, which naturally everybody wants to be as tax efficient as possible when you have a trust, and you avoid the costs, the fees, and the delay of probate, not to mention the publicity that I've mentioned. Some provinces, I believe Alberta doesn't have probate fees, but in British Columbia, in order to get that grant of probate, to get that court order saying, I'm the executor and I'm entitled to deal with the assets of the estate, that's going to cost your estate 1.4% approximately in taxes, which is just taken right off the top. You don't get the grant without paying the probate fees. And if you've got, let's say, $5 million worth of real estate or assets worth $5 million, you can do the math yourself. For every $1 million, your estate's going to have to pay $14,000 worth of tax just to get the grant. You can avoid that entirely with a trust, an inter vivos trust, I should say. And then, of course, there are some tax benefits if you deal with an alter ego or joint partner trust, which is what I'm going to get to now. And what an alter ego and joint partner trust is a very effective tax planning tool and estate planning tool that is sanctioned by the Canada Revenue Agency and has some requirements in order for it to be valid, but gives you the flexibility of an inter vivos trust without all the downside that comes with a non-alter ego, non-joint partner trust. So what is an alter ego trust? It is a trust settled by a Canadian resident who must be 65 years or older. And essentially, that person is settling their assets into a trust, which is their alter ego. Joint partner trusts are similar, except in that case, it has to be individuals or spouses who are Canadian residents, and they make provision for each other by settling a trust in terms of which only the settlor and the spouse will be beneficiaries during their lifetime. It doesn't mean that you're going to not be able to distribute the assets upon the death of the survivor, or in the case of an alter ego trust, that you cannot distribute your assets to other beneficiaries once you've passed. But during your lifetime, the sole beneficiary should be the settlor, or in the case of the joint spousal trust, should be the individual spouses. And then once you have passed away, the trust gets dealt with as any other trust would be, and the assets can be distributed. There are several major advantages to this type of trust. The first and most prevalent one is that your your transfer of assets into your joint spousal trust or your alter ego trust is tax neutral, right? So at the time that you're settling your assets into that trust, you're not creating a taxable event. There's a tax deferral, and that's different from a regular non-alter ego, non-joint partner trust, in which case there is a taxable event, and there would be the requirement to pay capital gains tax if capital gains have accrued on the assets that you have settled into trust. The second major advantage for an alter ego or joint partner trust is that there is no 21-year deemed disposition rule. And without getting into the weeds of what that is, under Canadian trust law, any trust that is settled, other than an alter ego trust or joint spousal trust, any trust that is settled at the 21-year anniversary of the date that the trust came into effect, there is a deemed disposition of all assets held by the trust, and that attracts a capital gain if there has been any. And so at the 21-year mark, the trustee will be required to pay capital gains tax on all capital gains that have accrued to the trust during the 21 years of its existence. And that could be a problem because there may not be the liquidity to pay that tax. But it might require assets to be liquidated. And it's just a massive tax imposition that is waiting in the wings after the 21 years lapse. Not so with the alter ego trust. During the lifetime of the settlor, the 21 years don't run. So assuming you settle the alter ego trust at age 65 and you live to be 95, that 21-year deemed disposition will not yet be triggered because it doesn't trigger during your lifetime. The other advantage, of course, is you get to control your own assets. So even though you're settling the trust, you are the only beneficiary of that trust, and you control the assets. Nobody's in a position to stop you from maintaining control over what is yours. It facilitates far easier estate administration, and that's the same as with a normal inter vivos trust. I mean, you would just have this position where the trustee is able to distribute essentially right after the settlor's death because they don't have to go through the probate process. It avoids the probate fees. It avoids the wills challenges that are so prevalent. And of course, in today's society where there are so many blended families, it also can protect against second spouses if the survivor of the two married spouses or common partners happens to remarry. And that we see all too often, unfortunately, these days, is that litigation is pursued because you have two parties coming together later in life. They've both had children from prior relationships. They want to leave something to those children, but of course, leave something to each other as well. And so setting up a trust, an alter ego trust, for example, will allow you to ensure that your children ultimately will receive the benefit of your estate as you had intended, and not that there is a surviving spouse that remarries and now some of your assets potentially are going to move to this new spouse. When it comes to creating an inter vivos trust, there are some considerations that you have to look at. And the first is the number of taxable events, the transfer of the capital assets into the trust. That's, as I've mentioned, creates a taxable event unless you have the alter ego or joint partner trust situation. And it's a hard and fast rule. It's strict. You can't create an alter ego trust or joint partner trust until you are 65 or one of the two partners is in fact is 65 years old. As I've mentioned, there is the 21-year deemed disposition rule, which doesn't apply, but would apply in the case of a regular trust. There are costs to set up a trust. So that's very important. I mean, depending on the size of your estate, it may not be worth your while to set up a complicated trust, to set up an alter ego trust. It really is fact and case and asset specific. So when you are considering trusts as an option, you need to remember that that is a reality, but better to spend the money up front and have a proper estate plan, have a proper trust in place than to risk litigation coming down the pipe later in life or after your death. Trusts also have maintenance costs. If you settle a trust, there is the cost of the trustee potentially that has to be reimbursed for their working on the trust. They get remuneration, and you can either set that or it would be set by various provincial statutes, but there is that potential cost that you're looking at. And also there are some trust filing requirements which started for the previous tax year and look to become more prevalent and more extensive, which you wouldn't have if you have your assets in your personal name. If you settle a trust, you're now going to have these additional costs of reporting and essentially filing documentation for CRA. There are some concerns that you need to watch out for, and in the interest of time, I'm not going to get too deep into them, but there are attribution tax rules, there's the tax on split income rules, and there are other potential taxes, such as in British Columbia, you have property transfer tax when you transfer property, you have speculation tax, empty homes tax, all of which you would need to know about, all of which you should inform yourself about when seeking advice from a lawyer setting up a trust. So I've spoken about the alter ego trust, I've spoken about the joint spousal trust, but the regular types of trusts that you'll see where somebody is not yet 65 years, generally speaking, would be a family trust or a situation where there is some planning required to ensure that A, the assets are protected, and B, the children, for example, of the settlor or the spouse of the settlor or other family members of the settlor are looked after and the assets of the settlor are properly managed. And so, as it says on the slide, there are many uses for a family trust, and the flexibility that a trust gives you is something that underscores or lies at the root of every trust, because why would you settle a trust with its potential downsides if there is not significant upside, which far outweighs the downside? So it really depends not only on the nature of your assets, the value of your assets, but also on your intended purpose. It may be that when you seek out legal advice, the lawyer says to you, based on what you're telling me, a trust is not the right option for you. We can do this in a different way. We can do it in a more efficient and less cumbersome way. One of the things that you can look at when it comes to family trusts is income splitting for children, which would allow them, for example, to have a tax efficient way of having their expenses and education paid. You can deal with corporations or interests that you have in corporations and put that into your family trust. And also you can protect estate plans or protect from tax for gifts being received from non-resident family members. So just some of the aspects that I'm highlighting for you here, but really this is something where when you meet with a lawyer and estate planner to discuss the option of a trust, you need to just be aware that there are upsides, there are downsides, but ultimately it is fact and case specific and really requires a deep dive for you and the lawyer to figure out whether it is the right vehicle for you. What are the risks of litigation? Karen has done a great job of outlining some of the myriad risks that you have when you make a will or when you don't make an estate plan. And you certainly are reducing those risks significantly by making a trust. All right, because one of the things, obviously, that you're not going to be faced with when you've settled your assets into a trust is a will's variation or a dependence claim isn't going to happen as regularly or even at all if the assets that you had are no longer in your estate. They don't pass through your estate. They pass through your alter ego trust or another form of trust. But there are litigation risks. And the point of today's discussion is that if you have a bad plan in place, you in all likelihood are going to see litigation during your lifetime or after you have passed away. So in the trust context, the most obvious and the most regular type of dispute that we see is when a trustee and a beneficiary are at loggerheads. The beneficiaries might feel aggrieved that the trustee is not providing them with the amount of money that they wish to have, or they have concerns about the trustee's honesty. They have concerns about the trustee being non-responsive or mismanaging the trust. And those kinds of disputes will, in many instances, result in either an application to court or a trial to remove the trustee or potentially sue the trustee for damages or compensation in the event that they have, in fact, misappropriated funds. They have, in fact, mismanaged the trust assets. And the test for removal of a trustee is always whether or not the removal is required to protect trust generally and is in the best interests of the beneficiaries generally. So the fact that one beneficiary takes the trust to court and wants to remove the trustee, that doesn't necessarily mean the trustee is going to be removed, because the court shows a great deal of deference to the settlor's selection of the trustee. And it's not because one beneficiary is unhappy about the trustee that the trustee needs to be removed. It's very fact specific. But the downside is that the trust is now involved with litigation. Litigation is expensive, and you, as the beneficiary of the trust that is not taking issue with the trustee's conduct, might end up with a smaller residue because the trust is now having to spend large sums of money defending itself, or the trustee is defending himself or herself at the expense of the trust. Another litigation risk, which is quite prevalent in trusts, is that you have to go to court to pass your accounts as the trustee. Now, what that means in broad terms is just that the trustee essentially has to have a registrar review their dealings with the trust. All money in, all money out will be analyzed and assessed by a registrar, and the registrar will either approve or not pass the trustee's accounts. That is expensive. That takes time. Again, it gets paid for from the trust because it is a statutory requirement to pass your accounts from time to time. And so that is something which might happen. The easiest way to avoid that is to make sure you have a trustee that is transparent, that is honest, that reports regularly to the beneficiaries, and then the beneficiaries can approve the accounts without having to go to court. And then there are possible clawback proceedings, and I don't want to belabor that, but if somebody is aggrieved about the fact that there has been a trust settled or that assets have been settled into that trust, the trust is still at risk of an industrious lawyer perhaps trying to claw back assets out of that trust on the grounds that they were settled improperly. They may have been a fraudulent conveyance. They may have been settled at a time that the settlor lacked capacity. So that is a reality. Could happen, but far, far less prevalent than litigation arising from wills. I mentioned earlier on that the other two documents that are necessary for your proper estate plan are a power of attorney for financial matters, as well as a healthcare representation agreement, as we call it in BC, but I know that in other provinces it's called something else. But you have three options, at least in BC you have three, in most provinces you have at least two. The enduring power of attorney is a document essentially allowing a substitute decision maker to deal with your property. As the name suggests, it is enduring, and it is intended to allow that person to deal with your assets once you lose capacity. The representation agreement, as it's known in BC, and again, it may have different name in other provinces, but the same concept applies. That's the document where you are allowing somebody else to make personal care and healthcare decisions on your behalf. And it's different from the power of attorney because it doesn't affect property. There are some exceptions to that rule, small amounts and small matters that can be dealt with by certain types of representation agreement. But the overriding concept is that you're appointing someone to make your decisions for your personal care when you're no longer capable of doing so. And then the third one, which is specific to BC, is a nomination of committee, where you can make a document saying, well, if all else fails and a court application for guardianship or committeeship is required, I'm nominating person X to act on my behalf. So the enduring power of attorney, as I mentioned, it continues despite the adult losing capacity. But what that also presupposes is that the adult must have capacity when they make the enduring power of attorney. So no good waiting around until you lose capacity to make the enduring power of attorney, because by then it is too late. There's two types of enduring power of attorney. You can have an immediate or a springing power of attorney. The immediate power of attorney, as the name suggests, becomes immediately valid. It becomes immediately operative, and the person you've appointed as your attorney is able to deal with your financial affairs using that power of attorney. The springing power of attorney is one that comes into play, or that takes effect when there is the occurrence of an event, such as you lose capacity and the power of attorney takes effect. But the difficulty is when springing attorneys are contemplated is, how do you prove that this event has taken place? Who needs to prove it? And what happens if they're unable to do so? So considerations when you're appointing a power of attorney or when you're making a power of attorney, the first and foremost, just like when you pick your trustee for the trust, who? Do not pick someone that you do not unequivocally and 100% trust. If you want it to be a family member, but you're concerned about ruptures within the family, so you say, well, you know what, I'm going to get my son, who I really trust, but his sister is going to be the joint attorney so that she can keep an eye on things, that's probably not going to work. Joint attorneys can be appointed, but ordinarily, unless the power of attorney specifies that they can act unilaterally, or if there are three of them, that the majority dictates, ordinarily, attorneys have to act unanimously. And if they don't, that document that you went to the trouble of creating becomes useless, because if they cannot agree, they cannot give joint instructions, the power of attorney fails to have effect. And then they end up having to go to court applying for a committeeship, which is what you try to avoid by having the power of attorney in the first place. And then the other thing you need to bear in mind is that an attorney is not entitled to charge any fees for the work that they do as an attorney for you, unless it specifically is specified in the power of attorney. The representation agreement, I'll deal with very briefly. It's about your personal care, your health care, your end-of-life decisions. It is not an advance directive. It is an authority that you are giving to your representative to make decisions on your behalf. And you can certainly make an advance directives and say, this is what I want to have happen in the event of, but it's not binding. It is not a legally enforceable document against your representative. But the whole point of appointing a representative is to have a discussion with this person, to make sure they understand what you want, to go through your advance directive with them, so that when these decisions need to be made, when these tough calls have to be made, they are able to do so, knowing what you would have wanted. Your healthcare representative cannot consent on your behalf to medical assistance in dying. That's something that this document would not allow, that would not be permissible, at least at present legislation. And once again, the consideration that is most prevalent is who should be the person making the decisions for you. Should it be joint representatives or just one person? The litigation risks when you don't plan for incapacity is the most glaring. If you don't have a power of attorney or a representation agreement in place, nobody can make decisions on your behalf regarding your finances or your healthcare decisions. That must then result in an application to court for guardianship or committeeship. You don't have control at that point as to who is going to be the committee. You don't know whether or not it's going to be your child or your spouse or somebody else. If none of your children wants to apply for guardianship, it's possible that the public guardian and trustee of whatever province is in play is applying, and then somebody who you don't know will be making decisions about your finances, about your healthcare potentially. And that's not what you want. You can avoid that by essentially making these documents in advance of losing capacity. Because, and this is very important, these documents, especially the power of attorney, give unfettered discretion and control over your assets to the attorney that you're appointing. And when there is any form of distrust or disagreement or a lack of harmony between family members and your children, chances are good they're going to want to fight over who becomes the committee. And I have been involved in many of these types of disputes where there are two camps that fracture the family, that essentially ruin the goodwill between family members, because one side says person X or person X and Y should be the committee, and the other side says it should be person Z. And that can result in protracted, lengthy, and extremely expensive court proceedings. And I'm talking the hundreds of thousands of dollars. And it really can be avoided by having that conversation ahead of time, by putting those plans in place well in advance of you losing capacity. So Karen, over to you.
There are a few takeaways. Obviously, plan. Or you could be and plan well, or you could be, or your estate could be involved in litigation for a number of years. And in many provinces, the cost of that litigation is borne by the estate itself. So it could mean that your intentions are they're not carried out, and that your estate is smaller to be distributed. There are many planning options, as Eric and I have canvassed, and be sure to, and there's no perfect solution. Everybody's family circumstance and assets are different. And also be mindful of family dynamics. Eric and Jonathan, I know that the most vulnerable family dynamic that I see, the one that is results in the most litigation, is the instance of a second spouse and the adult grown children, and maybe there's some minor children. So if you are in that family circumstance, be sure to plan. I would say those are big takeaways. Anything from you, Eric or Jonathan, on that front?
No, I think you've summarized it well. I don't have anything to add.
Yeah.
No, I definitely agree, Karen. That's where you see it the most, and it's not only the most prevalent; it can be the most protracted and heated.
That's right. Now, Jonathan, I've been watching the question and answer box, and you've been writing paragraphs to people that have been really helpful. So that's why we were seeing you looking down. You were typing a lot. There were a few questions ahead of time that I think I could maybe field one, and Eric, I think there's one that's more your bailiwick. One question was, what happens if wills are only witnessed by one person and not two? Now, depending where you are, that will may then not meet the formal requirements of the legislation. In Alberta, it wouldn't. You need two witnesses who are not beneficiaries, who are there when the testator signs the will. And so that would be an invalid will. Now, there is an ability under our legislation and rules of court to bring an application to the court to validate the will, notwithstanding that it doesn't formally comply with the legislated requirements. But again, I think probably the best thing to do if I were a testator and my will was non-compliant is to change that and make sure it is compliant, or it's going to require somebody to validate it. It won't get probated itself. The one question, Eric, that I have, that I share, that has been asked ahead of it, is the cost of establishing and maintaining a trust. Now, in BC, probate fees can be quite substantial. Do you know the 1.4% you were talking about of the value of the state? Do you find that trusts are as costly as that?
It's a good question, and it's a difficult one to answer. I mean, it's really how long is a piece of string, right? It really depends on the complexity of the trust and the structure and the potential reorg that you are putting in place. I mean, if you have a simple type of alter ego trust, which is fairly standard, it shouldn't cost that much to set up. But of course, there is the ongoing maintenance fee. It would likely be significantly less. Let's say your estate is worth 5 million, and you're looking at $70,000 essentially of probate fees just to get that grant of probate, you could probably come in at under that cost by some margin if you have a fairly standard trust that you are putting in place. But I want to be cautious here and say that it really is very case and asset and fact specific, because it could also be that the plan you're putting in place, the trust you're setting up, is significantly more complicated than you initially thought. And then the cost could be more than what the potential probate savings would be. But that's something that you need to discuss with your estate planning lawyer at the initial stage, because you'll have, and they will have, a fairly quick understanding of how complicated the plan is that you need. And generally speaking, I mean, when your estate is worth about $1 million, it's probably not worth going through the process of setting up the trust. It's probably not going to save you significant money. It's just a question then of whether or not you think there is value in having this trust set up to avoid a potential wills variation claim, or having the ability to manage your assets effectively, both before and after you pass away. But if that doesn't answer the question, it's because there is no easy answer, and I don't think that I'd be in a position to say it's definitely going to be.
No, but in some circumstances, I'm thinking that with the significant probate fees, you would be better off to have a trust from a savings perspective or a preservation of the estate assets perspective. And again, no one solution fits all. So. But that takes me to a question that I had seen from before the seminar, and essentially is like how best to minimize probate fees or to mitigate against them. And yeah, like you correctly say, Karen, is that in some circumstances the trust is the way to go. But there are others that you've touched upon, and again, case specific. Is joint tenancy planning the way to go? What are the risks of joint tenancy planning? Because there are risks, and so it may not be a one size fits all, but there are ways to minimize probate fees. And the best person to speak to about that is your financial planner, and of course your lawyer, working together cooperatively. I have also just seen, as one last point, we're 2 minutes overdue, but I have seen testators try to take up residence in another province where the probate fees aren't as significant and aren't a portion of the estate. It has to be a legitimate residency issue, but there are lots of options there.
I just wanted to add one point. There were a number of questions that came in, and I'm sorry I wasn't able to make it on the screen. That's why I was furious, typing away, answering the questions I could. Some were a bit long and they got rejected. But it has to do with probate, and there's a common misconception that probate is a legal requirement. It's not in Ontario. I can't speak for other provinces, but it is a practical requirement, because many third parties who are asked to rely on a will, banks, insurance company, land titles office, will require probate, so they can act on the will with the certainty that they have some protection because they've relied on a probated will. But if all the beneficiaries agree how the property is to be distributed, and there's no dispute and there's no need to go to a third party, you don't require probate, and you can avoid probate fees. Again, so just to emphasize, not a legal requirement, but practically it may become a requirement.
I think that's an excellent point. And if I could just add, and I think, Karen, you mentioned this in passing, but there is, of course, the ability to have a primary and a secondary will, and to deal with privately held shares, for example, through a secondary will, which doesn't require probate. So that's quite along the lines of what you're mentioning, Jonathan. But we don't have the time to get into the details of that today. We would suggest that you discuss that with your lawyer.
Okay, and on that, we've come to the end of our presentation today. Thank you for attending today, and of course throughout 2024. There's a link for the Ontario and Quebec Law Society certificates on the screen, as you can see. And for the BC viewers, the Law Society of BC title has been added to the chat as well. If you'd like to register for any of our events or watch replays of previous events, please visit the events section of fasken.com. Thank you for coming, and have a great afternoon and rest of the morning, depending on where you are.